Have you ever wondered what it would be like if a former president was disqualified from running for office again? Well, that's precisely the situation former President Donald Trump finds himself in. This is a historic moment of constitutional reckoning, with Trump's political future hanging in the balance due to legal challenges to his 2024 presidential candidacy. The disqualification from ballots in Colorado and Maine under Section 3 of the 14th Amendment for his role in the January 6th insurrection has brought us to this pivotal juncture. For those not familiar with the 14th Amendment, it's a critical piece of the U.S. Constitution that deals with citizenship rights and equal protection of the laws. Section 3, in particular, addresses the disqualification of individuals from holding office if they have engaged in insurrection or rebellion against the United States or given aid or comfort to its enemies. This provision, which was somewhat obscure in contemporary political discourse, has been thrust into the limelight following the events of January 6th. Legal challenges citing this provision have led to Trump being disqualified from the ballots in 2 states, a development that since brought us to this extraordinary constitutional showdown. What we're witnessing is a significant test of the Constitution's ability to uphold democratic norms and principles. It's a test of whether the Constitution can effectively bar an individual from seeking office if they've been implicated in acts of insurrection or rebellion. This extraordinary turn of events underscores the enduring power of constitutional principles to shape the trajectory of democracy. It's a stark reminder that the Constitution remains a living, breathing document, capable of addressing contemporary political crises and safeguarding the democratic process. As we move forward, the nation watches with bated breath to see how this constitutional showdown will unfold. The journey to this constitutional showdown was not a short one. It was a path paved by scholars who dared to delve deep into the annals of American history and constitutional law. 2 such scholars are Mark Graber and Gerard Maglioka, who found themselves drawn to a little-known provision of the 14th Amendment, Section 3. They unearthed this provision from its 19th century origins, bringing it to the forefront of our contemporary political discourse. This provision, which was initially obscured by the passage of time, came into sharp focus following the events of January 6th. The insurrection on this day, which shocked the nation and the world, prompted a series of legal challenges and debates centered around the applicability of Section 3. The question at the heart of these challenges was whether an individual who has engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof, can hold office. With these words from the 14th Amendment echoing in courtrooms and across media platforms, the significance of this provision became increasingly clear. But it was not just the words of the amendment that spurred these legal challenges. It was the meticulous research and interpretation by Graber and Maglioka that truly ignited this examination. They traced the roots of the 14th Amendment, its initial intentions, and its potential implications in our modern political climate. Their work highlighted the potential of this provision to hold accountable those involved in acts of insurrection against the United States. Their research became a beacon, guiding legal experts, politicians, and the public through the complexities of the Constitution, and illuminating the path to this historic showdown. Through their scholarly endeavors, Graber and Maglioka laid the groundwork for a renewed examination of Section 3's applicability in the modern era. They have underscored the enduring relevance of our Constitution, reminding us all that the words penned centuries ago still have the power to shape our democratic landscape today. Section 3's revival set off a chain reaction of legal battles. With the limelight now on this once obscure provision, a dynamic and intense legal landscape emerged. Progressive legal groups led the charge, taking up the mantle of democracy and challenging not just Trump, but his allies as well. Among these groups were Free Speech for People and Citizens for Responsibility and Ethics in Washington. They were the vanguards in this fight, their efforts echoing throughout courtrooms and into the public discourse. They drew upon the principles of accountability and the rule of law, pressing these issues to the forefront of American politics. Their work went beyond legal briefs and court appearances. They were shaping a national conversation about what it means to uphold our Constitution in the face of adversity. Each legal battle they fought, every challenge they made, was a statement. It was a declaration that those who threaten democracy will be held accountable, that the rule of law is not an abstract concept but a tangible, enforceable standard. Their advocacy was a clarion call, a reminder to us all that our constitutional norms are the bedrock of our democracy, and they must be defended. These groups' efforts were not just about disqualifying one individual or a group of individuals, they were about preserving the integrity of our democratic institutions. They were about ensuring that those who aspire to lead our nation are held to the highest standards of conduct, and that those who violate these standards face the consequences. Their tireless advocacy underscored the imperative of upholding constitutional norms in the face of unprecedented threats to democracy. As we delve deeper into this legal saga, remember that it's not just about one election or one candidate. It's about the principles that guide us as a nation, the values we hold dear, and the future we want for our democracy. The legal landscape shifted as courts grappled with defining insurrection and its application to modern political contexts. This shift was not only pivotal, but also served as a mirror reflecting the nation's struggle with the events of January 6th and the subsequent implications for democracy. Key to this shift were the precedents set in cases such as Representative Madison Cawthorn's challenge. This case, among others, served as a legal litmus test, probing the depths of Section 3 of the 14th Amendment and its applicability in modern times. These cases spotlighted the ambiguity of the term insurrection and the necessity for a clear legal definition that would stand up in court. The courts, in their wisdom, navigated this uncharted legal terrain with care and precision. They delved into the historical context, the intent of the framers of the Constitution, and the contemporary relevance of these provisions. For the originalists, it's important to recall this conversation between Senator Reverdy Johnson and Lot Morrill. During the Senate debate, only one reference was made to the fact that the President and Vice President were not specifically referred to as officers of the United States in Howard's draft. The text had listed members of Congress and state officials. It was unclear whether the disqualification clause of the amendment would apply to the top positions in the executive branch. "Why did you omit to exclude them?" asked Maryland Democratic Senator Reverdy Johnson. Maine's Lot Morrill jumped in to clarify. "Let me call the senator's attention to the words "or hold any office, civil or military, under the United States," Morrill said, ending the discussion on that point. In doing so, they laid the groundwork for a robust understanding of insurrection and its consequences. These decisions, in turn, paved the way for Trump's disqualification in Colorado and Maine. The disqualification of a former president from future ballots is no small matter. It's a testament to the profound power of the judiciary and the Constitution. These legal precedents not only clarified the parameters of Section 3, but also reaffirmed the judiciary's role as a guardian of constitutional integrity. The courts, in their interpretation and enforcement of Section 3, are not just interpreting a historical document. They are shaping the future of democracy, ensuring that the rule of law stands firm in the face of insurrection and upheaval. In the end, these legal precedents not only clarified the parameters of Section 3, but also reaffirmed the judiciary's role as a guardian of constitutional integrity in times of crisis. The courts have shown that no individual is above the law, and that the Constitution remains the cornerstone of American democracy. Trump's disqualification in Colorado and Maine marked a significant turning point, setting the stage for a Supreme Court showdown. As the highest court in the nation, the Supreme Court's ruling carries a weighty significance. It is tasked with answering one pivotal question. Do states have the right to bar individuals like Trump from seeking office due to their involvement in acts of insurrection? This question is not just about one man's political aspirations. It is a question that strikes at the heart of federalism, the delicate balance of power between the state and federal governments. How the Supreme Court answers this question could redefine the boundaries of state powers and their role in enforcing the Constitution. The Supreme Court's decision will not only determine Trump's political future, but could also set a precedent for how future cases of alleged insurrection are handled. If the court upholds the state's authority to disqualify candidates based on their involvement in insurrection, it could serve as a deterrent against future acts that undermine the democratic process. On the other hand, if the court rules in favor of Trump, it could potentially weaken the state's power to enforce constitutional norms and uphold electoral integrity. Beyond the legal implications, this Supreme Court showdown is also a litmus test for democratic norms in an era of political polarization. The court's decision will send a powerful message about the nation's commitment to upholding the rule of law, regardless of political affiliation. It will either underscore the importance of accountability for actions that threaten democracy, or it could signal a tolerance for such behavior. As the Supreme Court deliberates on this historic case, The nation watches with bated breath, understanding that its decision will shape the contours of American electoral law and the preservation of democratic norms for years to come. This high-stakes legal battle has profound implications for the future of American electoral law and the preservation of democratic norms in an era of political polarization.
Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.